I'm Christian Malesic, Executive Officer of the HBA of Berks County, Pennsylvania. And I'm not an attorney. I am an MBA. We're going to translate the lofty ivory tower language of the attorney into thingamajig, how you doing, and whatchamacallit, so that the average Joe and Jane contractor can apply it to their business today. Although this is based on Pennsylvania law, it will apply in most other states as well. So I started saying that a little bit earlier. We always need to think in terms of what happens in court. And I know you don't like to think that, and the reason you don't like to think that is the next bullet point. Many of you say, well, my word is my bond. And so the real question is, in current 2012 contractual terms in legal parlance, what is held higher in the courtroom? Your word is your bond, look a person in the eye, shake their hand, or a contract is meant to be broken? Any thoughts on that? What do you think is actually, a contract is just documenting everybody needs to fulfill the duties of the terms of the contract, or a contract is meant to be broken? Which way do the lawyers look at it?
It's meant to be broken.
That's exactly right. The evolution of contractual law, or maybe from most of our point of view, the de-evolution of contractual law in America, is that contracts are meant to be broken. Your word is not your bond. Contracts will and shall and can, maybe not shall, but will and can be broken at any time. However, the contract should specify exactly what the default provisions are. Default is the term that lawyers use to say, you didn't hold up your end of the bargain. You didn't pay when you were supposed to pay, but I did the work. Or I delivered the material and you didn't pay, or whatever the case may be. I didn't pay, you did the work. So that's a default, or an event of default. Contracts are seen as meant to be broken, and so the contract needs, and we'll talk about that as we get into specific clauses. Contracts are designed, or should be designed, so that they have provisions in there that say, what happens if you don't do what you agreed upon? Now that's key. And if you gloss over that, if you forget about that because we're both gentlemen here, we're both ladies, we're both professionals, whatever the case may be, we're both members of the same association, and you don't then put those default provisions, then when there is a default, you're relying on the judge to just make something up. And let's face it, judges are gods in the legal system. Whatever they say goes. They can make you hop on one foot, literally. I mean, and some judges have done some of these crazy things over the years. So, judges can be crazy. We give them the authority through our system to decide the disputes, and they can decide them in whichever way they'd like. So make sure you include in your contract provisions that allow the contract to be broken and what happens to each party if they do not abide by the contract.